I am Dr. Harpreet Kaur from Army Institute of Law, Mohali. The topic for the day is Doctrine of Pre-Constitutional Laws and Post-Constitutional Laws. Introduction of the topic. Constitutional law is the fundamental law of the land, laying down the structure and functions of the government and the relationships between the state and its citizens. It encompasses the principles that govern the creation, execution and interpretation of other laws. Pre-constitutional laws refer to the legal provisions that were in force before the current constitution was adopted. These laws often reflect the historical and societal context of their times, which may not align with the contemporary values enshrined in the current constitution. Post-constitutional law, on the other hand, are those enacted after the constitution came into effect, designed to be consistent with its provisions and principles. The transition from pre-constitutional to post-constitutional laws is a critical process in legal history, involving the review, amendment or repeal of existing laws to ensure they comply with the new constitutional frameworks. This is where the doctrine of severability and eclipse come into play. The doctrine of severability allows for the invalidation of unconstitutional parts of a statute without striking down the entire law. The doctrine of eclipse posits the pre-constitutional laws inconsistent with the fundamental rights are not nullified but remains unenforceable until appropriately amended. In India, Article 13 of the Constitution is particularly significant as it maintained that all laws, whether pre or post constitution, must conform to the fundamental rights, declaring any non-conforming sections void. This article ensures that the legal system evolves with the changing societal values and maintain alignment with the constitutional ethos. The impact of these doctrines and constitutional provisions on governance and society cannot be overstated. They ensure that the rule of law is maintained and that laws continue to reflect the moral and ethical standards of the society they govern. This dynamic interplay between pre-constitutional and post-constitutional laws underline the living nature of the Constitution, which adapts to the needs and values of its people over time. Through this lens, constitutional law is not just a static set of rules, but a vibrant framework that guides the evolution of a nation's legal system. Discussing the historical background. The historical background of the doctrine of pre-constitutional and post-constitutional laws is deeply rooted in the legal history and evolution of a country's constitution. In context of India, for instance, the distinction between pre-constitutional and post-constitutional laws is significant due to the country's transition from colonial rule to independence. Coming to the pre-constitutional laws, these are the laws that were in place before Indian Constitution came into effect on 26th of January 1950. Ancient India had a rich tradition of legal theory and practice, with texts like Chanakya's Arthashastra and Manusmriti dating back centuries. However, with the advent of British rule, the legal landscape changed dramatically. The British introduced their own system of common law, which significantly altered the existing legal practices. Many of the laws from this era were designed to serve the interests of the colonial power, often at the expenses of local populations. Coming to the post-constitutional law. After gaining independence in year 1947, India adopted its own constitution, which led to the creation of post-constitutional laws. These laws are created within the framework of the new constitution and are meant to uphold the values and principles enshrined within it. The constitution itself was an extensive document that laid out the rights of citizens, the structure of government and the power of various branches of the state. It marked a significant shift from the colonial legal system to a sovereign democratic republic. The transition from pre-constitutional to post-constitutional laws involved the review and adaptation of existing laws to ensure they were in accordance with the new constitution. This process was guided by doctrines such as the doctrine of severability and the doctrine of eclipse. The doctrine of severability allows for parts of a law that are inconsistent with the constitution to be severed, leaving the rest of law intact. The doctrine of eclipse holds that pre-constitutional law that are inconsistent with the fundamental right are not nullified, but remain unenforceable until they are amended to bring them in line with the constitutional provisions. This historical background is essential for understanding how modern legal systems have evolved from their pre-constitutional roots and how they continue to adapt and change in the post-constitutional era. It highlights the ongoing dialogue between the past and the present, where laws are not static but are continually interpreted and how reinterpreted in light of new societal values and constitutional mandate. Now, I will be discussing the pre-constitutional laws. Pre-constitutional laws are a fascinating subject, especially when examined through the lens of doctrine of pre-constitutional laws and post-constitutional laws. Here is a detailed note about the important aspect of these laws. First is the historical context. Pre-constitutional laws are those that were enacted before the establishment of the constitution. In many countries, these laws were influenced by colonial power or traditional legal system. For instance, in India, pre-constitutional laws included both the laws from ancient texts like Manusmriti and the laws imposed during British colonial rule. Nature and sources of these laws. These laws derived from various sources such as religious scriptures, royal decrees and colonial legislation. They were often a mixture of customary practice and formal statutes reflecting the diverse legal tradition of the time. Validity and continuity of these laws. The validity of pre-constitutional laws post the adoption of a new constitution depends on their consistency with the new constitutional framework. Many of these laws continue to be enforced by virtue of the doctrine of legislative continuity, provided they did not contravene the new constitutional provisions. Doctrine of severability and eclipse. The doctrine of severability allows for the separation of valid parts of a law from the invalid ones, ensuring that the entire law does not become void due to certain unconstitutional provisions. The doctrine of eclipse holds that pre-constitutional laws inconsistent with the constitution are not nullified, but remain dormant until they are amended to be consistent with the constitutional principles. Coming to the Article 13 of the Indian Constitution. In the Indian context, Article 13 plays a crucial role. It states that all laws enforced in the territory of India immediately before the commencement of the constitution, insofar as they are inconsistent with the provisions of part 3, that is the fundamental right, shall to the extent of such inconsistency be void. Impact on the legal system. Pre-constitutional laws have a significant impact on the contemporary legal systems. They form the basis of many current laws and legal principles, and their interpretation and application continue to evolve under the guidance of constitutional doctrines. Challenges and reforms of these laws. The transition from pre-constitutional to post-constitutional laws is not always smooth. It involves challenges such as reconciling traditional practices with modern constitutional values and ensuring that the laws serve the current needs of society. Application of the doctrine. The application of the doctrine of pre-constitutional and post-constitutional law, particularly the doctrine of eclipse, can be illustrated through several landmark cases in Indian constitutional law. For instance, first case is Bhikaji Narayan Dhakras versus State of Madhya Pradesh, AIR 1955, Supreme Court, page number 589. This case marked the formal pronouncement of doctrine of eclipse. It was held that Any law inconsistent with the fundamental rights is not invalid, but is merely overshadowed by the fundamental rights. The inconsistency can be removed by a constitutional amendment which would remove the eclipse and make the entire law valid. The next case is Deep Chand versus State of Uttar Pradesh 1959. In this case, the Supreme Court held that doctrine of eclipse applied to pre-constitutional laws that were valid at their inception. However, it does not apply to post-constitutional laws since they are invalid from the very beginning if they are inconsistent with part 3 of the constitution. The next case is Panna Lal Binjraj versus Union of India, cases of 1957, page number 233. This case further explored the application of the doctrine of eclipse, where it was determined that pre-constitutional laws inconsistent with the fundamental rights are not nullified, but remain unenforceable until they are amended to align with the constitution. These cases demonstrate how the doctrine of eclipse has been used to navigate the complex relationship between pre-constitutional laws and the fundamental rights enshrined in the constitution. The doctrine ensures that laws from the pre-constitutional era are not discarded outright, but are given the opportunity to be amended and brought into conformity with the constitutional values. This approach reflects the adaptability of the legal system to observe and reform existing laws within the framework of constitutional principles. In conclusion, pre-constitutional laws are an integral part of legal history and continue to influence the legal landscape. The doctrines that guide their transition to the post-constitutional era ensure that they evolve in harmony with the principles of the Constitution, reflecting the dynamic nature of law and society. Now, coming to post-constitutional laws. Post-constitutional laws refer to the statute and legal provisions that were enacted after the adoption of the Constitution. These laws are created within the framework of the new constitutional order and are expected to uphold the values and principles enshrined within it. Unlike pre-constitutional laws, which may continue to exist subject to their consistency with the Constitution, post-constitutional laws must be made in full compliance with the constitutional provisions from the outset. In Indian context, post-constitutional laws are those enacted after 26 January 1950, the day the Constitution of India came into force. These laws are subject to the scrutiny of the constitutionality by the judiciary, especially in terms of their alignment with fundamental rights. Article 13 of the Indian Constitution plays a pivotal role here, as it explicitly states that any law that contravenes the fundamental rights is void to the extent of its contravention. This means that while pre-constitutional laws are given a chance to be amended and brought into line with the Constitution, post-constitutional laws do not have this leeway. They are invalid from the moment they infringe upon the constitutional rights. The doctrine ensures that the legal system remains dynamic and adaptable, allowing for the evolution of laws in accordance with the changing needs and values of the society. It also underscores the supremacy of the Constitution as the ultimate law of land, guiding the creation and interpretation of all subsequent laws. Post-constitutional laws, therefore, are not just new laws, but are also a reflection of the constitutional commitment to uphold the rights and liberties of the people. They represent the ongoing process of legal development in the light of constitutional directives and societal progress. Doctrine of severability. The doctrine of severability, also known as doctrine of separability, is a judicial principle that plays a crucial role in the context of pre-constitutional and post-constitutional laws. It addresses the question of what happens to a law or a part of it when certain provisions are found to be unconstitutional. The doctrine of severability is the concept that if certain part of a laws are declared unconstitutional, those parts can be severed from the rest of the law, which can remain in force if it is incapable of functioning independently of the unconstitutional sections. Application of the doctrine. This doctrine is applicable when a law contains both constitutional and unconstitutional provisions. The court will attempt to separate the valid part from the invalid ones, maintaining the integrity of the law to the extent possible without the unconstitutional provisions. It is applied in international arena as well as unilateral model law or international commercial arbitration. The unilateral model law is the framework adopted by many countries to standardize their arbitration laws. It implicitly recognizes the doctrine of severability by allowing an arbitration tribunal to rule on its own jurisdiction, which includes any objections with respect to existing or validity of the arbitration agreement. International Chamber of Commerce, the ICC arbitration rules acknowledge the separability of the arbitration clause from the main contract, meaning that the invalidity of the main contract does not necessarily affect the validity of the arbitration agreement. Cambridge University Press. In context of international arbitration, it is widely accepted that an arbitration agreement is severable from the underlying contract. This means that even if the main contract is invalidated, the agreement to arbitrate dispute can still be enforceable. Article 13 and severability. In India, Article 13 of the Constitution provides the basis for this doctrine. It states that any law that is inconsistent with or in contravention of the fundamental rights is void to the extent of inconsistency. The doctrine of severability is an extension of this article, allowing for the rest of the law to stand if it can function independently of the void sections. Pre-constitutional laws versus post-constitutional laws. For pre-constitutional laws, the doctrine is particularly relevant because these laws were not made with the current constitution in mind. If part of these laws violate fundamental rights, they can be severed and the remaining provision can continue to operate. However, for post constitutional laws which should be made in compliance with the constitution, the doctrine ensures that any oversight or error that leads to unconstitutional provision does not invalidate the entire law. The significance. Doctrine of severability ensures that the legislature intent is respected to the greatest extent possible while still upholding the supremacy of the constitution. It prevents the invalidation of entire laws due to parts that are unconstitutional, thus preserving the law's original intent and application where it does not conflict with constitutional mandate. In a sense, the doctrine of severability safeguards the constitutional validity of laws by allowing for the accession of unconstitutional elements while preserving the rest of the law, provided it can stand on its own and fulfill the legislative intent without the exercised portion. This doctrine is integral to maintain the rule of law and ensure the legal system remains consistent with constitutional principles. Coming to the doctrine of eclipse. The doctrine of eclipse, rooted in Article 13 of the Indian Constitution, asserts that laws predating the Constitution are not nullified, but overshadowed by fundamental rights, becoming dormant until amended to align with constitutional mandate. Historical rulings have cemented its application, clarifying that while pre-constitutional laws can be reviewed, post-amendment post-constitutional laws contravening fundamental rights are void ab initio. This doctrine underscores the constitution's supremacy, ensuring that even as the societal values evolve, the legal framework remains consistent with the fundamental rights guaranteed to the citizen. In a case of Keshav Madhav Menon versus State of Bombay, AIR 1951 Supreme Court 1282, the court held that pre-constitutional laws inconsistent with fundamental rights are not null and void, but remains in a state of eclipse. In case of Bhikhaji Narayan Dhakras versus State of Madhya Pradesh, 1955 Supreme Court, page number 781, the Supreme Court analyzed the provisions of Article 19 Clause 1 Subclause G, which guarantees the freedom to practice any profession, and Article 31 Clause 2, which relates to the right to property. The court held that CP and Bearer Motor Vehicle Amendment Act 1947, which conferred extensive powers on the provincial government to create a monopoly in the motor transport business, was inconsistent with these articles. However, the inconsistency was removed by the Constitution First Amendment Act of 1951 and the Constitution Fourth Amendment Act of 1955, which amended Article 19 Clause 6 and Article 31 Clause 2 respectively. In case of State of Gujarat versus Ambika Mill, cases of 1974, Supreme Court, page number 1300, the court examined the provisions of Article 19 Clause 1 Subclause F, which dealt with the right to acquire, hold and dispose of the property, and Article 13 Clause 2, which states that the state shall not make any law which take away or abridge the right conferred by Part 3 of the Constitution, and any law made in contravention of this clause shall to the extent of the contravention be void. The case involved the Bombay Labour Welfare Fund Acts of 1953 and its application to the state of Gujarat. The Supreme Court held that the impugned provision violates the fundamental rights of the citizen under Article 19(1)(f) and were therefore void under Article 13 Clause 2. It also addressed the issue of discrimination in the definition of establishment under the Act, which was found to be violative of Article 14, the right of equality. Analysis of Article 13 of the Constitution of India. Article 13 of the Constitution is a cornerstone for the protection of fundamental rights, serving as a shield against any legislative or executive action that may infringe upon these rights. It embodies the principle of judicial review, allowing the courts to scrutinize and invalidate laws that are inconsistent with the Constitution. Article 13, it has Clause 1, it declares all pre-constitutional laws void to the extent of their inconsistency with Part 3 of the Constitution, which enumerates fundamental rights. Article 13 Clause 2 prohibits the state from making any law that takes away or limit the rights conferred by Part 3, and any law made in contravention of this clause is void to the extent of the contravention. Article 13 Clause 3, it defines the law broadly to include ordinance, orders, bylaws, rules, regulations, notifications, custom or usages having the force of law. Article 13 Clause 4, it clarifies that nothing in this article shall apply to any amendment of the Constitution made under Article 368. In the grand tapestry of Indian jurisprudence, Article 13 of the Constitution stands as a sentinel guarding the sanctity of the fundamental rights. It has been subject to judicial scrutiny in a constellation of landmark cases, each a thread woven into a rich fabric constitutional law. These cases are not mere footnotes in legal tomes, but pivotal movements where the spirit of the Constitution was affirmed and its contours defined. In case of Ramesh Thapar versus State of Madras, AIR 1950, Supreme Court, page number 124. This case evaluated the constitutionality of a Madras law concerning the entry and circulation of the printed materials. The Supreme Court held that freedom of speech and expression under Article 19(1)(a) could only be restricted on the grounds mentioned in Article 19 Clause 2. The law was found to be overly restrictive and not falling within the exceptions provided, thus violating Article 19 Clause 1 Subclause A and was declared void under Article 13. Second case is A.K. Gopalan versus State of Madras, AIR 1950, Supreme Court, page number 27. In this landmark judgment, the court examined the Preventive Detention Act 1950 in light of Article 22 of the Constitution, which provides protection against arrest and detention in certain cases. The court held that Act did not violate Article 22 and that the protection under Article 21 is not absolute. However, this case is significant for its interpretation of the procedure established by law under Article 21. In case of L. Chandra Kumar versus Union of India, AIR 1997 Supreme Court, page number 1125. This case dealt with the constitutional validity of the Administrative Tribunal Act 1985 and whether it took away the power of judicial review from high courts. The Supreme Court held that power of judicial review over legislative action vested in the high courts under Article 226 and 227 and in Supreme Court under Article 32 of the Constitution is an integral and essential feature of the Constitution, constituting part of its basic structure. In case of Indira Nehru Gandhi versus Shri Raj Narayan and another, AIR 1975 Supreme Court, page number 1590, this case involved a challenge to the election of the then Prime Minister Indira Gandhi. The court evaluated the constitutional amendments made to validate her election and held that the amendments were subject to the basic structure doctrine, thus reaffirming the power of judicial review under Article 13. In case of Keshwan Madhava Menon versus State of Bombay, AIR 1951 Supreme Court, page number 128. This case clarifies that pre-constitutional laws inconsistent with the fundamental rights are not null and void, but remain inoperative until they are amended to comply with the Constitution. These cases reflect the robust application of Article 13 in evaluating the constitutionality of the laws and upholding the supremacy of the Constitution over any legislative or executive act that infringes upon fundamental rights. They also highlight that judiciary's role in interpreting the provisions of the Constitution to ensure that rights of the citizens are protected. Now coming to the comparative analysis of both the laws. The doctrine of pre-constitutional and post-constitutional laws is a fascinating subject that varies significantly across different jurisdictions. While India's approach to pre-constitutional laws is rooted in its colonial past and the transformative journey to independence, other countries have their unique historical and legal context that shape their treatment of such laws. United States, the US Constitution being one of the oldest written constitution, does not have the concept of pre-constitutional laws in the same sense as India. However, the US legal system does have the concept of federal common laws, which includes principle inherited from English common law prior to American independence. The US Constitution's supremacy clause ensures that federal law takes precedence over any conflicting state laws or precedent. United Kingdom, the UK does not have a codified constitution like India or the US. Instead, it operates on an uncodified set of legal and constitutional principles that have developed over time. As such, the distinction between pre-constitutional and post-constitutional laws is not applicable. However, the principle of parliamentary sovereignty means that no parliament can pass laws that future parliaments cannot change. The comparative analysis, the Indian approach to the pre-constitutional laws is unique due to its historical context of transitioning from colonial rule to an independent republic with a written constitution. This contrasts with the US, where the constitution itself was a part of the country's formation, and the UK, where the evolution of laws has been continuous and without a definitive constitutional beginning. The Indian judiciary's active role in reviewing and adapting pre-constitutional laws to fit within the constitutional framework is a distinctive feature that underscores the dynamic nature of its legal system in comparison to the more static approach of the US and UK's flexible uncodified traditions. Each jurisdictional approach reflects its own legal culture and historical development, illustrating the diverse ways in which legal system can evolve and adapt to changing societal values and norms. Coming to the conclusion of the topic, in the grand theatre of jurisprudence, the doctrine of pre-constitutional and post-constitutional laws dance like a timeless ballet, harmonizing the old with the new, the past with the present. It is a doctrine that whispers of history's depth, echoing through the hallowed halls of justice, ensuring that the laws which govern us are not mere relics of the bygone era, but living testaments of our evolving civilization. This doctrine is the loom upon which the fabric of our legal system is woven, intervening threads of ancient statutes with the vibrant hues of modern constitutional mandate. It is a testament to the resilience of law, a phoenix that rises from the ashes of the pre-constitutional form, reborn under the nurturing light of the Constitution to serve the present and future generation. As the world turns and societies flourish, the doctrine stands as a sentinel, ensuring that every law, every decree, every ordinance bows to the supremacy of the Constitution. It is a symphony of legal principles where each note resonates with the fundamental rights and freedoms that are the chorus of democracy. Thus, in the doctrine's embrace, we find the wisdom of ages and the promises of tomorrow, a delicate balance between preserving our heritage and paving the way for progress. It is a beacon of hope, a reminder that our laws are alive, breathing entities that grow and adapt just as we do. In this doctrine, we find the true spirit of law, immutable yet dynamic, rooted in history yet reaching for the start. I hope you liked the lecture. Thank you and have a nice day.